Well, good afternoon. It's a real pleasure to be here today with my friend and colleague, Clark Bolton. Clark has the honor, I think, of being able to say that he has traveled the journey from a whistleblower to a whistleblower attorney. And what we want to talk about today is that journey. So, Clark, good afternoon. It's a pleasure to be here with you today.
The same, Marcus. How are you today?
I'm doing well. I'm doing well. So, what I would like to do is just take you through that journey, Clark, and we'll unpack what it is you do now. And for those that don't know Clark, Clark is is head of the whistleblower department at Morgan and Morgan, and we'll talk about his experience there. But Clark, why don't we just sort of start at the beginning? You became a whistleblower yourself, but before we got to that point, I understand that you served for years as a fraud examiner, if I'm getting that right.
Yes. First thing I want to say is I actually head up the processing unit, the intake unit for the whistleblower program. James Young, my colleague and partner, oversees both the government and the whistleblower.
I understand. Okay. All right. Thank you for that. But tell me,
Sure.
what did you do as a fraud examiner, which I think leads into the story?
Yeah, it's a long story going back at least 20 years. Um, Actually, about when I got out of the Army 38 years ago, I pursued an undergraduate degree in criminal justice. And the plan was for me to go to get my bachelor's degree in criminal justice and then go on to law school. Well, I had about a 20 some odd year hiatus from law school because I actually took a job right after graduating. I started working as an investigator for a public defender's office.
Okay.
And the first case they handed me was a homicide case. And I had no business conducting an investigation involving a homicide, but the attorney who was working with me on it really taught me some valuable lessons. And that kickstarted my 20 some odd year investigative career prior to becoming an attorney, which at some point led me to doing fraud investigation work, which
Right.
then directly led me to this line of
Well,
work.
you were, if I understand this, you were a fraud examiner, and then you later came to a company known as WellCare, right?
Yes, that's correct. And I got my certified fraud examiner's certification in 2005. After I left New York State, I was working as an investigator for the New York State Capital Defender Office, handling capital murder cases. And I was doing a little bit of healthcare fraud, a little bit of workers' comp fraud, and I thought the certification would work. And then at some point, I was contacted by WellCare Health Plans here in Tampa. I was living up in Connecticut at the time, and they asked if I'd want to come down here to Tampa to run their investigation unit for their special investigation unit.
So my understanding is you come to Tampa, you take on that role, and you began to witness some things that did not sit well for you. Is that?
Yeah, that's correct, and it happened real quick. Within a week of me working, my first day on the job was 9/11/2006. And my new boss, who was the director of SIU, said he was going on vacation to Europe and that I was going to be responsible for handling the unit while he was gone. Hence, I started receiving all the emails that he received normally. And I came across an email that was quite disturbing to me because it involved communications at a high level in the company about potentially trying to use non-disclosure information or promising not to disclose the potential fraud that a provider was getting involved in to state regulators as a means to negotiate a higher reimbursement of what we were trying to get back from the guy. So I immediately went to my boss's boss and said, we can't be involved in this. We can't make promises about a non-disclosure. We're required by the statute here in Florida to report potential cases of fraud. Therefore, we can't be involved in trying to negotiate with a provider based upon promising not to disclose. So that didn't go over too well, because he basically turned to me and said, well, that's a business decision. And I said, oh, okay. And but that started it. And over the series of additional about 12 months, I reported internally on multiple other issues that I saw, and I essentially got the same response back.
So after that went on, what ultimately happened to your employment there?
It got to the point where I got an inquiry from a federal agency about an investigation of ours, and I conducted some due diligence on that to report back to the agency. I think it was the FBI, is my recollection. They were asking about a provider, and I, through my due diligence investigation on what we reported back to the FBI, I saw there was discussions and concern about reporting what they actually did versus what they reported to the FBI. So it was clear to me that they misrepresented some information, and I went to the head of the compliance department and urged him to do a self-disclosure to the government about these misrepresentations that we made. And then they got into a much bigger discussion about all the issues that we were facing that I had blew the whistle on internally. And during that conversation, he asked me, well, how did it get to this point? And I said, well, it's because the Special Investigation Unit was in the medical economics side of the house, and they had no understanding of what our function was. Therefore, everything came down to a business decision, as opposed to what was required either under the statute or the regulations. And the vice president of compliance said, well, we'll just conduct our investigation and get back to you. He started indicating to me very soon thereafter that this was nothing, and they were going to basically blow it all, sweep it all under the rug. So I proceeded to write a fairly lengthy memo wherein I told them that they needed to do a self-disclosure, that there were issues that could potentially put folks in criminal or civil liability, and that it was going to impact the company, have a substantial impact. I forgot to mention in that conversation I had with I did mention it that we were, the SIU unit was in a improperly located within that, within the company. And a week after I wrote that memo and submitted it, the director of HR and my boss's boss, the one who told me on my first whistleblowing that it was a business decision, pulled me into a conference room and told me that, oh, by the way, they're reorganizing the SIU and moving it to another section. And as a result thereof, I no longer had a job.
So after you were terminated by WellCare, I understand that you landed, we didn't land as a job, but you landed in an attorney-client relationship with a firm that pursued that legally. Am I getting that right?
Yeah, you did. What I initially did, and this is actually a big part of what I do today, which is educating whistleblowers, not only in my practice, but also at conferences that I go to speak at, is I was a very experienced investigator handled some very serious claims in litigation, but I had no idea how to blow the whistle effectively. Really, I didn't. I first went to an employment lawyer who wanted to simply contact the WellCare and just submit a letter of demand and try to negotiate some sort of compensation. And that's not what I wanted. I wanted WellCare to do basically the right thing, do the self-disclosure, go through that whole process and make it right again. And so I left that attorney and went over to Clearwater, and Judge Coleman, who was at private practice, I spoke to him, and he says, I think after about 5 minutes of interviewing me, he asked all the right questions. He said, I've got somebody I think you need to talk to. And that was James Hoyer, which was Bill James, Chris Hoyer, former state federal prosecutors, had formed a law firm over in Tampa, and they were specializing in whistleblower law. So that's where I ended up.
Well, and let's talk for a moment about whistleblower law, because you focus in a type of whistleblower case, and most people, I think, when they think whistleblower, think of the type of case you're involved in, the Qui Tam type of case. Yeah. Now, there are other types of whistleblower cases involving retaliation in the employment context, and there's some overlap. Am I getting that right?
Yeah, there are a host of whistleblower programs at the state and at the federal level. Right. My whole practice is focused in terms of what I do is Federal False Claim Act whistleblower law, which has a Qui Tam provision, which permits a whistleblower to file a complaint under seal in federal court and receive a bounty for that, anywhere between 15 and 30%.
And the attorney bringing that type of case receives a fee as well, if I'm getting that right.
Yes, it does have a statutory fee provision. The normal way it works is you have a contingency agreement with the client, and then
So in your situation with WellCare, how long did this litigation last? I take it, did it go into litigation?
Well, I mean, it was 5 years.
Okay.
But that case was very, very unusual for a lot of reasons. First, when we filed that case, I filed in October of 2007. And if you may recall back then, there was a raid performed by the U.S. government on the corporate headquarters during a board meeting in October. It was shortly after I had filed, and in fact, I was at a local anti-fraud conference, and I received a phone call from the investigator at James Hoyer's, former FBI agent, Al Scuderi, and he tells me over the phone, there are 200 agents raiding currently right now the WellCare headquarters. And my first words back to him were, I'm not the only whistleblower, because I knew my case didn't in any way justify 200 agents going in over there. So we immediately knew that there was another whistleblower. But secondly, what really impacted me personally is you file these cases under the statute, you file them under seal. Okay, what that means is you file them with the court, and the court puts it under seal, and no one else knows about it. The only folks that know about the existence of the case are the prosecutors and us. So no one else is supposed to know about it. And we filed here in the Middle District of Florida in Tampa. Fine, no, there were no problems. But we also filed in Tallahassee for some state claims. And the clerk up there, for whatever reason, it was properly marked not to be filed under seal. not to be unsealed. And that's precisely what she did. She put it out on, I guess, the version of Pacer that the state has. And so I immediately became known as that guy who blew the whistle on WellCare because my name came out. So every financial newspaper was reaching out to me, sending reporters and everything else to my door. So at the time my kids were very young, my 2.5, and my little one was barely a year old. So we spent a lot of time in Disney World.
Well, that begs the question, 5 years of this, how did you get by for half a decade as a whistleblower?
Yeah, a known whistleblower, exactly. Well, I had a little bit of a career going in the healthcare fraud world, but I couldn't get a call back. No one wanted to call the guy who blew the whistle on a multi-billion-dollar corporation where 200 agents then execute a search warrant. So I was getting no traction at all on sending out resumes and reaching out to my network. No one wanted to touch me. So I just got my private investigator's license and I started working, doing regular private investigation type of work for attorneys. And then I also started developing my healthcare fraud consulting, which I did a fair amount of that as well. And that's essentially how I kept, our mortgage paid and everything else. And fortunately, my wife worked as well. So it was a tough go though, because really being exposed as a whistleblower for that size of a company and having that impact here at the local community, it was difficult.
Well, it finally came to a head and came to an end, right?
Yes.
Tell the audience, if you will, how that turned out.
Yeah, it's pretty much, I think it's the only case that I'm aware of where the entire C-suite of a multi-billion-dollar corporation was held to account. In other words, the CEO, the CFO, general counsel, and multiple division heads, presidents, and vice presidents were indicted federally under healthcare law violations and convicted. Furthermore, the corporation itself signed a deferred prosecution agreement with the government, and then they settled the False Claim Act case, which were separate whistleblower complaints filed. So there was myself, I was whistleblower number 2. There were 2 that filed after me, but 1 filed before me. And so we settled on an ability to pay for $137.5 million. So that was a fair amount of money there. But ultimately, I think WellCare probably ponied up over $500 million when all was said and done. With all they also had an SEC case that was settled, and I think they also had an investor case that also settled. So it cost them a lot of money. And then ultimately, the executives, some of the executives actually served time.
And this resolution led to the next chapter of your career, right?
Yes. So my wife asked me when I turned 50 what I wanted to do. I said, remember when I told you when I got out of the Army I was going to go to law school? Well, I think it's time. So I went to law school while maintaining my business, healthcare fraud, and consulting, and I did law school in 3 years and passed the bar. In my 3rd year, James Hoyer brought me on as an investigator, doing basically what I'm doing now, which is assessing cases as they come in and prepping them for filing.
And now you work at Morgan & Morgan, right?
That's correct. Morgan & Morgan has a complex litigation group. and there are several practice areas. My area, the Qui Tam, but we also have class action, mass torts, and the complex lit group. So yeah.
So focusing, if you will, on what it is you do, which is, I think, an intake function, it sort of begs the question to me of what would be the attributes of a great Qui Tam case?
That's a great question, because that's it in a nutshell. I mean, if the whole roll of the die is selecting the right cases. And selecting the right cases is something that takes a great deal of experience and knowledge in order to effectively do it. You would think that the government is interested in pursuing all fraud that you can find, and that's simply not true. The government just doesn't have the resources to do that. Okay, so not only, and I sort of divide cases into threes. Right, there's the first bucket is the good case with a defendant who has the ability to pay. Right, that's the ideal case. And when I say a good case, what do I mean by that? I mean that it has all the that the relator, him or herself, is very credible. The whistleblower is very credible. That they have corroborative documents. The allegations are clear, and the law seems to be on very clear. There are no issues that we often have to research, like on the public disclosure bar or a first file issue. So we have to work through all those issues. And then when we're talking about here are frequently government regulations, you really have to delve into the regulations and understand the complexities that are involved, and then tie that all into the evidence. And then that's how you, if at the end of your assessment, at the end of the intake process, you arrive at it. Okay, this is a green light. We also, have to be clear whether or not proceeding on a case is financially viable too, because many of these defendants are not. They may have stolen the money, but the money's no longer there. So there's an ability to pay issue. In fact, what we frequently use are the factors that the government uses when they decide whether they're going to intervene or not.
So what are some of those factors?
So the factors typically, well, the number one factor that the government uses is there any public safety issue, right? That's the first thing that they look at. If there is, then they're seriously taking a look at it. Secondly, obviously, the False Claim Act is a tool that the government uses. It's their primary anti-fraud tool to go after the money and bring it back. So, but they also have to do an ROI. Is the amount of money that they anticipate coming back, is it worth assigning it to an AUSA or two, or having, in many cases, there are also Department of Justice main attorneys involved, and then you have multiple investigators. It becomes a very expensive proposition to bring forward a case. So we look at that as well. And then I mentioned before, we look at all the regulatory framework, whether there's cases that are already out there that have been settled successfully by the government, whether they pursue them or not. So there's sort of, through this whole process, you're checking off, saying, okay, yeah, this looks good, this looks good, this looks good. So that's the first one. That I told you there's three. There's also a second bucket where you have a good case. In other words, you've got the evidence, a good, credible relator, whistleblower, but maybe you got a difficult ability to pay situation. What do you do then? And that's another calculation that we have to make. and in many instances, we decide not to, because we don't want to put, I mean, we represent whistleblowers, and I'm sure you can recognize that once you make a decision to be a whistleblower, there's no going back, right?
As you know personally.
As I know personally, exactly. You're going to impact the rest of your life, especially in the careers that many of these whistleblowers are in. So it's our obligation to protect them. And I don't want to put a whistleblower in a situation where they have to go through 5 years of litigation. At the end of that, we can't collect any money. It doesn't benefit him or her at all. In fact, it just hurts them. So what my normal practice is, right before, they'll tell me, I always ask them up front, what do you want to do? And invariably they'll tell me, well, they want to pursue a False Claim Act case. But before I actually file the case, I call them again and I say, are you sure? Is this what you really want to do? But that also leads to the question of, how confident do I have to be to file a case? And that I guess I should step back and explain how. Do you want me to explain how the process?
Yeah, I'm
works?
interested. I'm interested in the Clark Bolton approach.
Yeah. Okay.
Cases.
So I don't have hard, fast rules on a lot of things, except I will not take a case forward that I don't feel confident in. Right. We get a lot of calls here at Morgan & Morgan. We do well over 1,000 every year, and we have two of the best investigators in the nation. One of our investigators, our lead investigator, David Rain, he's former FBI ASAC here in Tampa, and he actually headed up the Enron investigation for the Bureau. And the other investigator we just brought on about a year ago, Kyle Ford, he's a 33 years HHS OIG and handled some of the best healthcare fraud settlements and convictions in Florida. In fact, he was the lead investigator on the WellCare case, and that's where I first met him. So they do wonderful work for us, really working these cases up. So I have a lot of help, but at the end of the day, we have to feel really confident that we can file these cases and win, because the statistics are overpowering. 90% of the cases that the government chooses to intervene, because that's what happens. We file a case, okay, and under the statute, there's 60 days in which the government must make a determination about whether or not they're going to intervene or not. But there's an opt-out where they can say, well, we need more time, and then they file an extension with the court, and the court grants the extension invariably, and they usually do it in 6 months increments. So we file the case under seal, and if the government chooses to intervene while they're doing that investigation at some point, the odds of settling it successfully is around 90% or more. Now, the opposite is also true. If the government decides not to intervene, the odds of success drop to less than 10%. So we really need to feel confident about that, and about that the government is going to intervene. And we have been doing this long enough that we pretty much know what the government is. Well, let me step back. We usually know what the government is interested in terms of the type of cases that they're looking for, because we've seen enough of them, we've handled enough of them. But that's not enough. You have to properly prepare these cases. They're, as you can imagine, they're very they're driven by the facts and the evidence in the case, right? When you bring these cases forward, you really would like to have a lot of corroborative evidence of the allegations, which brings up a point that I like to share with everyone. And it's my philosophy, and I think it's the correct one. Everything is, getting everything is, more is not better in a FCA case, a False Claim Act case. In fact, it can hurt you and hurt you bad. And I'll explain that. When I say more, I mean more evidence is not good. In fact, in many scenarios, if you abscond with the entire hard drive of the corporation thinking that you've got all the evidence, well, you may also have walked away with proprietary trade information. You may have walked away with privileged information that was communicated between the defendant and their outside counsel. There's a host of things that could just go really sideways on you if you're not careful there. That's why if I have a relator, whistleblower, who's currently employed with the company, I take a very measured approach to how we collect the information. Now, there are plenty of opportunities to take whatever information we want, usually, and we can do it in a way that protects all these whistleblowers. For example, I never recommend to my whistleblowers to just jump on their computer system and start searching, right? That's the last thing you want to do, because corporations today have pretty good controls over tracking, right? We don't want them to do that sort of thing. So, these Instamatic cameras, and those are great tools to screen capture. And then I always invariably get the question of, what about PHI, HIPAA laws? And there are exceptions. There are exceptions built right into the HIPAA law that'll permits a whistleblower, if they're operating under good faith belief that the provider's engaged in healthcare fraud, to bring those documents to me as an attorney, who then conducts an investigation, and then I can bring it to the government. So that we have that HIPAA exception. And then there's also public policy exceptions that come into play for taking documents or evidence and permits or protects the whistleblower from the defendant pursuing sort of counterclaims and that sort of thing. So there are protections there, and I like to in the scenario where I have a current employed whistleblower, to really take my time and hone in on the kind of documents that I think are useful. Because ultimately, at the end of the day, it's very rare, Marcus, that you ever get the smoking gun, right? You're not going to get the diagram that shows how we're going to, steal hundreds of millions of dollars. You don't get that.
Right.
But what you do get are snippets of here and there showing scienter knowledge of the fraud, and then the actual fraud. And of course, we always need sort of claims data if we can get it, because that's the essence of it, right? And under the case law, we're obligated to prove that a false claim has been submitted. So we do need to get some sort of claims data, or at least information about that claims data, so that we can put that into our complaint. But at the end of the day, that's what I'm trying to do, is get that information. And then under the statute, we're required to develop what's called a disclosure statement. Okay, and a disclosure statement is any and all relevant information. We need to provide that over to the government. Right. So in preparation of filing the case, we put together a disclosure statement. And the disclosure, there's nothing in the statute that says what a disclosure statement needs to look like. But having done this long enough and worked with enough AUSAs, I've learned what they're looking for, which is basically the evidence in an organized manner, and also in a way, because our relators are the subject matter experts of that company, and usually on the issues that are on point, so they can direct the government in going after the documents that would further prove the case. So we develop like an investigative plan, and then we put together witness lists and an org chart. So it starts to become more of not just the documents that you send over in a box, but a comprehensive.
How you put it all together.
Put it together for them. That's right. I mean, my job as the attorney is to put it in a nice bow, because when I give a case, when we file a case, when I meet that AUSA, I know that AUSA's got another 40 or 50 or however many other Qui Tam cases. They're totally overwhelmed, and they lack resources. So my job is to make their job as easy as possible in terms of showing them where the documents are, how to get the documents. Under the statute itself, it permits the government to pursue what are called civil investigative demands, or basically subpoenas. And the government can issue those to the defendant or any other third party to gather the information that they need to determine whether or not the allegations are true.
Yeah.
So we try to guide them that way.
So we've talked about Qui Tam and sort of your approach to it. And I know that you came up through the healthcare sector. That was your journey. But for the audience, to help them understand this, my understanding is the Qui Tam applies to many different sectors wherein federal funds are distributed, or there are recipients of federal money. Am I getting that right?
You are accurate. The government, well, their budget is what, $5 trillion, whatever it is, whatever that number is. Whatever the government is the number one, it's the largest employer and the largest consumer, basically in the world. So wherever the government spends their money, anywhere in the world, you have a potential for a false claim case, because if it's being used or redirected fraudulently, that's a potential Qui Tam.
So just to kind of explore this for a minute, does your practice extend beyond the healthcare sector or does Morgan & Morgan, let me define this more broadly, extend beyond healthcare and other sectors and the application of Qui Tam to those?
Absolutely, it does. We about 75 to 80%, which is on par with the industry. Department of Justice keeps statistics, and about 75 to 80% of their cases, the Department of Justice settles, are healthcare related. For example, 2 weeks ago, Department of Justice released 2023 statistics on Qui Tams. They brought back $2.68 billion in fiscal year 2023, which ended in September. And of that, I think 1.8 was healthcare related, and that's just in raw dollars. That's not in the percentages of which were healthcare and which were not. But it crosses the spectrum. We at Morgan & Morgan, we work on defense procurement, non-defense procurement, SBA matters. I'm a veteran myself, and I am a son of a disabled veteran. So I have a strong interest in service disabled veteran-owned small business fraud. So I've got a number of those cases currently filed all across the country.
We talked for a moment recently about the notion that there have been COVID-related payments to many millions of Americans, and whether or not that's generated sort of its own cottage industry of Qui Tam or similar type of whistleblower cases. Just curious whether that's in fact the case.
Yeah, when they passed the CARES Act, roughly at some point, I think we had $3 trillion that hit the road there, and with little or no oversight. And we all knew at the time that there was going to be significant fraud, and all the IG reports recognized that it was rampant. In fact, it got so bad that foreign organized crime was getting involved. We thought initially that the Qui Tam provisions would give us an opportunity to pursue these cases. In fact, I filed one of the very first ones in October of 2020, but we found that hasn't been the case, and there's multiple reasons for it. The first one, I think, is because this goes back to what I said earlier. There has to be an ROI, and most of the fraud that was committed under these PPP schemes, most of that money is gone. So you might get the person who committed the fraud, but they've already spent it. The money's gone.
These are individuals for the most part.
Typically individuals, yes, that's correct.
I see.
So the money's gone. So what the government has decided to do is use the criminal statutes to go after these folks primarily. Now, that doesn't say they haven't used Qui Tams, but I mean, there are millions of loans, and I think there's maybe less than 20 Qui Tams, successful Qui Tams. So that those statistics alone tell you it's not been very effective, but there's reasons for it. And the statutes themselves changed over time, or the regulations, excuse me, not the statutes. The regulations changed over time under the SBA laws. Therefore, as a result of that, there's a little ambiguity, and the agencies tend to be somewhat cautious about using something like the False Claim Act when there's maybe some sort of excuse or confusion involved with how people handle these kinds of cases.
I see. Clark, we could go on for a long time, but let me start to wrap this up in the interest of time. And one question I have for you is, you may have listeners that are younger lawyers, or at least newer in their practice, whose interest may be piqued by your area of practice. And I'm curious as to what advice you'd have for those lawyers. Is this an area worth pursuing? If it is, what kind of steps and advice would you offer to folks who will follow in your footsteps?
Great question. This is the only practice area that I know. I love it. I couldn't say enough, and I feel very blessed that I'm here at Morgan & Morgan, and I can focus all my practice on Qui Tam cases. But that's rare, and it's rare for a number of reasons. There's probably less than 500 of us that practice it full time, and the reasons are they usually take a long time. Okay, the average Qui Tam case goes between 3 to 5 years. The government only intervenes in about 20% of all Qui Tams. So 80% of the cases that are filed are not intervened. And most of those, 90% of them aren't successful. So it's a very difficult practice area to get into. I mean, when people hear about the 100 million, the 300 million, the 900 million that a friend of mine got in Boston on a non-intervened case, he got 900 million. When they hear numbers like that, along with the fact that you get multi-million-dollar statutory fees, they think, wow, that's where I want to go. That's where the money is. And unfortunately, it's not like that. You have to build a practice from, if you're just coming into it from scratch, basically. And it's very difficult to get really good cases. And that's what it takes. This is not a numbers game. This isn't like you want to get 100 calls. You want to get one call, and it's got to be the right call, right? And the right case. And my advice to anyone, is do not pursue that case alone if you have no experience. There's so many sort of strategic decision making that goes on prior to even filing a case. Where do you file it? You have nationwide jurisdiction in which to file these cases. And if you have any nexus, in terms of the decision making, we frequently sit down and with our team and discuss where are we going to file this case. First, we have to find out where we can, what nexus we have in which jurisdictions. Then we try to determine what do we know about that jurisdiction. Do we know any AUSAs there, or the civil chief, or whatever? What kind of relationship? What do they seem interested in? These are all questions that people who don't practice in there have no clue about, and they have a dramatic impact on the success of these cases. Because you also need to know about these jurisdictions. They may have a great AUSA, but the AUSA is only handling part of it. You have agency OIG investigators, HHS OIG investigators, or Department of Defense investigators. What's their office like? Are they overwhelmed? Do they have the ability to work the case up? That level of knowledge that we've gleaned over the years through our contacts and communications with various people all goes into our decision making. So anyone that thinks that they can just put together a complaint and file it, and oh, by the way, the government's going to investigate it, that's a recipe for disaster. And I would urge nobody to do that. There's an organization that I belong to, the Anti-Fraud Network. It's called TAF. It's comprised of us folks that do Qui Tam work, whistleblower work, but we also do SEC whistleblower and a few other whistleblower programs. It's a real collaborative. I would urge anyone who's interested in this line of work to reach out and join that organization. We have a distribution list, emails that on a daily basis, all these issues that I talked about, the developments in whistleblower law and strategies and contacts and all that information is discussed, and we try to help with making smart decisions, because that's what this is about, is helping each other. Because if there's bad law, there's bad law for everybody, and we don't want that. So we try to make sure that we only bring good cases, and that's what we strive to do. And that's what I would urge anyone, is to reach out. I reach out on a daily basis to folks that I think are mentors to me, that I consider them mentors. I reach out to them all the time on cases and have conversations about where to file, or what sort of strategies we should consider, what kind of conversation should I have with the government, and those sorts of conversations are all sort of ongoing. So my biggest advice, if you're interested, is join TAF and then reach out and find a mentor who practices in this space, and go that route. And that would be the best way to do it.
Okay. Well, Clark, we're going to wrap up in the interest of time. I will put up on the screen a graphic which will display your information, but can you tell us how any of our listeners could, contact you?
Yeah, well, my direct line is 813-225-6744. I have to read it off my phone. I don't ever call myself. Or you can reach me on via email, cbolton@forthepeople.com.
Okay. Well, Clark, like I say, we could go on forever, but we'll
go
more
that we can talk about, but that's fine. Get that.
I know. We'll wrap it up at this point, and hope to have this chat in this format again.
Absolutely. Anytime, Marcus.
All right. Well, thank you.
Thank you.